109 Regal Construction.
My name is Lou Adolphson. I represent the insurance company of New York, Inscorp, in liquidation, and the superintendent of insurance and the New York Liquidation Bureau in connection with this matter.
You want any rebuttal time, Counsel?
I would like to take 3 minutes for rebuttal.
3 minutes. Okay, proceed.
Your Honor, I'd like to start by saying that I recognize that this case factually is not the same as the Worth case. The Worth case presented itself as a case where there was no negligence. They conceded in the underlying action as to the person providing additional insured coverage. I'll call them the named insured. And also the staircase was finished. They were away from the job. That's not here. What I think is important to recognize here, though, is that if you look at the law in this area, all of the law that has held that additional insured coverage is owed in this circumstance and similar circumstances was essentially made by the First Department. In this particular case, and also another case called Bovis versus Garrido, which was on appeal to this court and recently settled, the same issue came up. And interestingly, in Bovis versus Garrido, Justice McGuire wrote the majority opinion 3-2, based on Worth saying that additional insured coverage is not owed. In this case, Justice McGuire wrote the dissenting opinion 3-2, saying on his, again, that he thought additional insured coverage.
Is Worth a unique set of circumstances in your mind?
No, I don't think it is. I think it's about a very strong case for what the court said. But I think if I could tell you now, you know, what this case is about. The way this case started for Inscorp before it was in liquidation was I had the benefit of someone in the company who said to me, how can they be covered? I mean, look at what happened here. The joist was painted by URS, the person we're giving additional insured coverage. How can that be? The only answer you could give at that time was the First Department would say.
Well, what about the answer that was the deal you made, that you made a contract to supply insurance for any injury that's a result of your work, whether it's your fault or somebody else's fault?
Well, I don't, Your Honor, I don't think that's what it says. I think, you know, if you look at the history of the law, the two cases, Maroney and Worth, that come from the Court of Appeals, both hold.
Haven't we looked at how to define arising out of?
Yes.
And we've said it just needs a causal relationship. We haven't said it needs to be negligence of that party.
I agree, Your Honor, but I do think here that what you have in this particular case is unique. This wasn't that someone else painted the staircase. This wasn't that there's a point that the First Department makes that Regal itself could have been ordered to paint these joists. It didn't. What happened was the evidence that's in this record is that it was painted by URS
so why is
for a purpose having nothing to do with this.
Why is that dispositive, that they painted it?
Well, I think I go back to I think this is a contract issue. It's not a policy issue. In other words, you could have just created additional insured coverage by saying you're insured, period. No other language.
Could also have said we'll give you insurance for anything arising out of our fault, but they didn't say that. It said for anything arising out of our work.
Well, it said the phrase itself, and Your Honor, Judge Piggott, in your I'm going to tell you this in the opinion you wrote in Worth, you didn't mention when you said it the first word, which is liability arising out of your ongoing activities for the additional insured. Actually, didn't say for the additional insured in the Worth case. Didn't
so
have
this
that
says liability.
It's the liability
arising out of Regal's operations.
But it didn't arise. That's the point I'm trying to make. I mean,
why isn't this a very typical case?
In the First Department's view, any
What's
time.
unique about this case? The general work we know is under Regal's umbrella, right?
I guess what I would like.
Is this one fact that they painted the and make this a unique case?
No, what I'm trying to get across with this issue about the First Department is, in our view, people who do this for a living, and I do and I have for a long time, was involved in both Garrido and this case, ironically. To us, it just always seemed wrong that if the person seeking additional insured coverage caused the accident, that they could say, oh, well.
You may not know that. You may not know whether liability is going to attach until after the trial.
Well, that's another problem.
But it may.
See, that's another problem that this case has.
Liability may arise out of Regal's
There's
operation.
been no finding of fault here, right?
No, well, this case was settled. What we had was the classic that you get in personal injury cases, somebody saying somebody else said something.
Does it make any difference what the rule is as long as it's clear? I mean, the First Department rule, I guess, is simple.
It makes you liable all the time. Any time the person.
Can you write around that?
Wasn't that the purpose that URS asked for this coverage? Asked to be an additional insured?
Well, Your Honor, I mean, I can't, it's not in the record, but I could tell you the insurance industry didn't think that this is what they were doing. The new.
Well, what I don't understand is if you didn't want their coverage, if you didn't want to be responsible for the defense and indemnification, if it wasn't the negligence of your employees, then why didn't that appear as an exception in the contract?
Yeah, it's the same question I have. Why can't you just write around it?
I think they thought they were. That's language fails, Your Honor. We try to draft things, and I think the intent of this was the liability of the additional insured had to arise out of the ongoing operations of the person providing it, meaning.
Well, this did arise out of your operations. You were operating at the very, it was your employee who was injured, operating at the very moment he was injured.
Well, I'm afraid we might get into metaphysics, and I don't want to. I thought that what Worth was pointing out was that we are not going to say that when the person who is supposed to get additional insured coverage, in this case URS, is the operative party. There's no showing that they would anything that was done by Regal caused this accident.
What about the boards that he was working on or walking on? Who did those things?
He was walking on the site to show something to a demolition.
But isn't that Regal's responsibility?
Well, was he involved in what he's supposed to do? He absolutely was. I'm taking it back.
But he fell.
Right.
Walking on those boards, right?
He fell.
That wasn't URS's problem, right? Or they didn't have anything to do with that.
He wouldn't have fallen at all if URS hadn't, unbeknownst to him, secretly having nothing to do with the whole job other than, as the testimony is in this record, that they wanted to make the site look good because the city was coming to inspect. So they painted. He walks along and he slips and falls. It really has nothing to do with his ongoing operation. But yes, there's one way you can look at it where he's walking along. It's part of his ongoing operations. But I think
you may be able to be indemnified later on or have some sort of subrogation claim or something.
Well, once you get AI, you're more or less, that's it. It's over, and that's what happens here. And what I want to say also, Your Honors, is this case makes another distinction, which you'll see all over the brief of my adversary, which is any time it's an employee, the First Department says it arises out of your operations for the ongoing insured. Again, another distinction. Pacific, it was not an employee. The person who fell was somebody else. So that's where the law now stands. So
how hard would it be? I mean, how hard? Why was it? Why is it, or was it ever difficult to write a clause that says we indemnify you for liability arising out of our fault? There have been such clauses for a long time.
I don't know of any such, Your Honor. I will tell you the new clause requires an act or omission on the part of the named insured. That's here. There would be no such act or omission.
Would we be opening kind of a? I hate to always use Pandora's box, but in Worth, the situation was so strange. I mean, where you had like a third contractor coming in and doing something that may not have been within the contemplation of the parties. And here we have what obviously we all know. Would the next case be? Well, we didn't know he was going to stay until after 5/15, and therefore, that one doesn't fall as an additional insured because of the court's holding in Regal Construction, and then somebody who comes too early, or all of these things that In other words, instead of clarifying it, we're creating a loophole that will always be used every time there's an issue.
Well, you see, Your Honor, the way we regard it as people who do this, we regard it as a worth fine. We said, hey, wait a second, they're not right. Every time somebody slips and falls at a construction site who's an employee, it's not the fault of the named insured, and he shouldn't have to provide indemnity. Like there's a case involving Con Edison where Con Edison, it's very clear, Con Edison caused the guy to fall. It was their job. Even Garrido. Garrido was a case where my guy made the hole in Garrido at trial. We admitted it. But at trial, we proved that he had taken out of the contract the obligation to cover the hole. It's called doing the protection. And so what Bovis and AIG, same AIG as here, argued is, well, he made the hole, so it arose out of his work for the additional insured.
Did you have a reservation of rights? Were you in that case, did you say?
Yes.
All right. Did you have a reservation of rights
Yes.
clause about it?
Yes.
You had one here.
Yes.
But obviously, where does it stand now?
Well, it's the Appellate Division, First Department. On oral argument, it sounded like we waived, because Judge McGuire was all over me on that issue. But I said to him, we reserved, and I pointed out, and Your Honor, there's a history of reversing a lot of things lately. I said what we did was we reserved in the beginning. They brought a third-party action, threatened us, and what did our claim person do? They said, okay, we'll defend. And the argument was made that we should have sent another reservation of rights letter. And I said if we did that, that aggressive law firm that represented URS would have had us in a DJ,
Right.
and BP Air.
Right.
And I said to them, Your Honor, you all got reversed in BP Air because you tried to decide the issue, and the Court of Appeals said it's a duty to defend issue. So what I'm saying here is I think this is all part of that same thing that we would like to see.
They'll have your rebuttal time. Counsel?
Good afternoon. William Cleary for National Union Fire Insurance
So
Company.
you say you have to look to the complaint and to see if there's a reasonable possibility of coverage.
I
In
missed
the
the first
underli-
part of your
in-
question.
In the underlying complaint.
Yes.
That's what you have to look at,
Yes.
right? To see if there's a reasonable possibility of coverage here.
That's correct.
If it may possibly there may possibly be liability.
And here the underlying complaint stated that Mr. LeClaire was acting in the course of his employment at the time of his injury, and that is what we believed triggered the coverage here.
If they are not negligent, they had no involvement in how this accident occurred, why is it fair to require the defense and indemnification?
I will, for the purposes of the question,
I'm not
I'll
saying
assume they're not.
that's what
okay,
happens here.
We'll assume they're not
I'm just
negligent.
saying, right. I'm assuming
Because
if
there's a
it turns
policy,
out-
I believe it's a policy issue, Your Honor, in that the employer is the person in the best position to know what the dangers are, and his insurer is the best one to assess the risks.
So it's not
posed
based
by
on,
their
it's
work.
not based on the insurance contract
Well,
language here?
it is also based on the insurance contract in that it says liability arising out of your operations. And if you're an employee, if your employee is hurt on the job while in the course of his employment, it's difficult for me to wrap my mind around how that is not arising out of your
What's the
operations.
significance of URS painting the door?
Well, first of all, that's a factually disputed matter. But
Let's say they painted the door.
Okay.
What's the significance?
counsel wants you to focus like a laser on that painted joist to the exclusion of all else, which is is in complete contravention of the language in Worth, which says the focus is not the precise cause of the accident, but the general nature of the operation in the course of which the injury occurred. Now, in this particular case, Regal had contracted with URS to do demolition. Mr. LeClaire was there in furtherance of that contract, and in the course of his employment, he was in an area where demolition was being performed. He was walking through that area on a walkway, which he testified was there for safety purposes, so people wouldn't have to walk on the joist.
That Regal was involved in, right? The walkway was...
Yes, Regal's subcontractor put the walkway there.
Right.
He was walking through on that walkway which, as I said, he testified was there for safety purposes. He stepped off that walkway onto a joist to point out a wall that was going to be demolished, and he fell. Now, he points as the cause of that accident is the painted joist, but it's just as, it couldn't have happened without him stepping off the sidewalk.
Is
the
Worth
walkway.
a very different set of circumstances?
It's an extremely different set.
Is it an unusual set of circumstances?
Very unusual.
How so?
Several reasons. First, there was a finding in that case that the subcontractor was not liable. I mean, not only not liable, not negligent. He was.
If you had such a finding here, would that change the result?
It depends on other facts, Your Honor. There were other facts involved.
Leave all the other facts the same, but let's have, suppose there's a stipulation in this case that his client had no fault. Does it change the result?
It may, Your Honor. If it was his employee based on the policy language, I would say probably not, because it was part of their operations. If he was in the course of his work at the time he was injured, I think it's fair to say it was in the course of their operations and something that that URS was contracting to have covered under Regal's policy as part of the work contract. I mean, this is a liability shifting process, and I think this Court recognized it in Kenny versus Lisk and Maroney, that the purpose of these insurance procurement clauses is to shift the risk from the owners or the overseers to the people actually doing the work, because they are the people who know what the risks are and are in the best position to assess them.
If we give the contract provision that kind of broad Maroney meaning here, when would National Union's coverage ever click in?
Well, it would become excess above theirs.
That was the purpose of having the prime contractor?
Yes. Well, that's part of it. I mean, the
Secure
coverage,
this insurance?
National Union's coverage doesn't go away. In this situation, it becomes excess over the Regal coverage. If there was a situation where a URS employee was doing something negligent and got hurt, it would be URS's responsibility, because it has no connection with Regal's operations. I mean, there could be myriad subcontractors on the site. Some of them may not have proper insurance. If their insurance disappears for some reason, then our policy might have to kick in. There's multiple various situations where the National Union policy could respond first.
Anything else, Counsel? Go ahead.
Just a couple of other points. One is that we're going back to the painted joist. There's no evidence in the underlying record that URS painted that joist. It's all hearsay evidence by Mr. LeClaire, who had a conversation with people he says were supervisors for URS.
Yeah, but if they did, you don't think it's dispositive in any way?
I don't think. No, I think the result is correct, but that's the basis of their entire argument.
Was the hearsay problem raised below?
Yes, it was. It's in the record at R472 through 478, R482, and Regal's response to it is at 430 in the record. And one other point I'd like to make is that the Court has asked why couldn't the clause been written to specify that negligence on the part of the potential initial insured would not be covered, and such clauses do exist, and I cite two cases in our brief at footnote 10 that dealt with such language. And other than that, unless the Court has further questions, I'm...
Okay, Counsel. Thank you. Counsel, rebuttal?
Your Honor, I just want to make sure we make this record clear. I know reviewability in the Court of Appeals is very important. First of all, the two references that he made in the record, 472 is in the underlying action where defense counsel hired by INSCORP is arguing over whether or not these facts establish 240 liability. So it was not being, AIG was not objecting. Similarly, on page 482, when he points to an objection, that's an objection being made by URS, who's saying, I didn't get a chance to cross-examine these guys. 406 is their motion for summary judgment, and on page 406, AIG never mentions that they object to this as hearsay at all, because they don't object to it. In fact, we were also eager to move for summary judgment. I moved for summary judgment before issue was joined because I didn't realize they hadn't filed an answer yet. They had moved to dismiss, and the judge had to convert the whole thing into summary judgment. We all wanted summary judgment in this case. And also, Your Honors, you know, every personal injury case that I've ever had involving a slip and fall, it's always somebody comes up and says that the manager of the supermarket said, I told you to clean that up an hour ago. It always gets into evidence. It's an exception. It's an admission. It's always there. So, Your Honor, thank you.
Okay.
So much it is.
No,
that's it.
no.
Okay.
Thank you both.